Do you know or understand what your obligations are with the new industrial relations laws? Hi, I'm Cliff Carter and I'm the Managing Director of the Human Resources and Safety Consultancy, Cartech Consulting. July the 1st, 2009 heralded the beginning of a new chapter of industrial relations for small business with the abolition of work choices and the commencement of the Fair Work Act. The new Fair Work Act has been implemented in 2 instalments, with the second instalment occurring on January the 1st this year. These changes will have a significant impact on your business. So who do these new laws apply to? Well, they apply to almost every business or constitutional corporations or PTY Ltd businesses are covered. If you operate in a partnership or as a sole trader, then these new laws do not apply to you. The new Fair Work Act will capture over 80% of businesses in Australia. There have been many changes to the legislation, however there are 6 key changes that you should be aware of. The first of them is the National Employment Standards, or NES. The NES outlines the 10 minimum conditions of employment for all employees. These minimum standards are a 38-hour working week, unpaid parental leave of up to two years, 4 weeks annual leave, however shift workers may be entitled to 5 weeks, flexible work arrangements, that is, if one of your workers has a child under school age, they could request that you adjust their working arrangements. 5, long service leave. Number 6 is personal leave up to 10 days paid per year and 2 days unpaid. 7 is compassionate leave, which is 2 days paid for each event every year. 8, community services leave. Employees are to pay the employee for attending jury duty for up to 10 days per year. And unlimited unpaid leave for emergency services leave. 9, termination and redundancy provisions. 10, public holidays. Employees have the right to refuse to work on the grounds of family responsibility. And finally, there's the Fair Work Information Statement. This document summarises the NES, and a copy of which must be given to every one of your employees, existing and new employees. The second item is unfair dismissals. Work choice exempted businesses that had less than 100 employees. The new laws have reduced this to 15. So if you employ 15 or more staff and you do not terminate an employee in the appropriate manner, you leave yourself open for a claim of unfair dismissal. However, if you have less than 15 employees, there is a new Small Business Fair Dismissal Code which has been developed to assist you through the termination process. The third item is modern awards. From January the 1st, 2010, several thousand awards have been condensed into approximately 140. Many of the terms and conditions in these new awards may be very different to what you have been using. For example, in many awards, the loading paid to casual workers is 25% instead of the previous 20%. In many instances, these new awards are covering groups of employees that have previously been award-free. Groups such as managers or salaried staff may now be covered by an award. Item 4, enterprise bargaining. Individual workplace agreements can no longer be negotiated. Enterprise agreements must be a collective agreement, either as a unionised or a non-unionised agreement. Your new agreement will be compared against the new award to ensure employees are not worse off, and this is called the BOOT test, the Better Off Overall test. Item 5, union right of entry. Unions have the right to enter your workplace to speak to any union member or potential union member, to investigate breaches of workplace laws and to hold discussions with employees. However, there are rules that the union and employers must follow before the union can enter the workplace. Item 6, record keeping. Did you know that you are required to keep certain records about employees and that their payslips must also contain certain information? So what happens if you get it wrong? The penalties for breaching the rules are significant. Employers can be fined individually up to $6,000 for each breach, and the business can also be fined up to $33,000 for that same breach. So what should I do? Even if you only have 1 employee, it's important that you receive the correct pay and conditions. Your first tasks should be to identify which new modern award applies to your business and ensure that you comply. Other tasks that you should do, if you haven't done so already, is to implement a number of policies and procedures for matters such as dealing with poor performance, termination, workplace bullying, harassment, discrimination, and flexible work practices. Issue new contracts of employment outlining the employee's new terms and conditions. You should also conduct a review of your record-keeping processes. And finally, develop a procedure for managing union right of entry. By taking these initiatives, you will not only ensure compliance with the Fair Work Act, but also your employees will have a clear understanding of what their workplace requirements are. If you need any assistance, I can be contacted by the Business Growth Centre. Thank you.